This is the Planning and Land Use Management Committee. I've been joined by Councilmember Harris Dawson and Councilmember Fuentes. We'll go quickly through, we'll first hear from our Planning Director on item number 12, and then we'll hear the consent calendar and go from there. So welcome, Mr. Bertoni.
Thank you, Chair Weezer and
Item 12.
Members of the committee. Vince Bertoni, Director of City Planning. Just a few things. At the City Planning Commission's regular meeting last week, we had a very lengthy meeting largely regarding the issue of home sharing, and the Commission heard the home sharing ordinance and made a recommendation to the full City Council, which will be coming to you, will be forwarded to you, so you'll be able to hear that after the break. Very lengthy discussion. I think we had about 630 people in attendance. They're roughly down the line 50-50 in terms of supporting or opposing how the ordinance was drafted. The only other issue I'd like to raise today is the Department of City Planning and the Department of Building Safety have entered into an enhancement partnership plan, and this is a partnership agreement that the Department of Building Safety has been initiating with those departments that they interact with on a very often at a high level. And so this is a partnership plan that really lays out how the two departments are going to work together and provide better and more comprehensive services to our customers. So we're very excited to have entered that with between our departments, and Mr. Frank Bush, the new Director of Building and Safety, along with me, signed that agreement. And with that, that concludes my report, and I'm happy to answer any questions.
Great, thank you. Any questions or comments? Yes, sir, Mr. Harris Dawson.
Thank you so much, Mr. Chair, and thank you to our Director of Planning. I just want to make sure I put back on the table every time progress on our specific plans and community plans. Folks are very eager to hear about how that's going, especially in South LA, but I think around the city that's an issue.
Thank you, Councilmember, and I've been working with our new Deputy Director, Mr. Kevin Kelly, to come back with a report to this committee. Thank you.
Thank you. So we'll note and receive and file item number 12. We'll go through the consent calendar. Item number 3, 4, 5, 7, and 8 are all on consent calendar. So moved and seconded by Mr. Dawson. No objection. We'll approve those on consent.
So, Councilman, on 8, the city attorney will be requested to prepare the ordinance.
Yes.
Okay.
Thank you.
And on 7, we're approving the city attorney ordinance.
Yes.
Okay.
Okay. We have Councilmember Ryu with us today. He'd like to speak on an item, so I'd like to call that item to order. I believe it's item number 11. So we will call item 11 and have our CLA read it into the record, and then we'll have a public comment by Mr. Ryu.
Sure. Councilman, item 11 is a city planning department report and a city attorney prepare ordinance. This is the ICO that impacts 5 neighborhoods in the city located in CD 4 and 10.
Thank you. Welcome.
Thank you, Mr. Chairman. Thank you so much for taking the item out of order and allowing me to speak. And thank you very much to my colleagues, Councilmember Felipe Fuentes and Councilmember Marquis Harris Dawson, for your amazing work in this committee. And I'm here today to speak on item number 11 regarding the interim control ordinance. In March of 2015, our City Council adopted an interim control ordinance offering protections to 15 distinct and unique neighborhoods throughout Los Angeles. Upon entering office last summer, I'm a couple of days shy of 1-year anniversary, along with my freshman colleague, Marquis Harris Dawson. One of the first actions I took was to introduce a motion to extend these protections to 3 additional neighborhoods in Council District 4. They are Sherman Oaks, Brookside, and Sycamore Square. In our residential neighborhoods, bubble field redevelopment is pushing up housing prices with out-of-scale homes. These larger properties provide no additional housing to the city, but do outprice our residents. Additionally, mansionization makes it even harder for the middle class middle-class families to become homeowners. Out-of-scale and out-of-character development has also pitted neighbor against neighbor. Our planning department is working extremely hard to formulate more tailored zoning options to Recode LA, the baseline mansionization ordinance, and the baseline hillside ordinance. But while these ordinances are being created, we have lost hundreds of homes, displaced middle-class families, and changed the historic character of our neighborhoods. Currently, we're witnessing homes being speculatively developed in a low-interest rate market, and if we are not careful, this could leave large areas of Los Angeles in the same over-leveraged fiscal position as it was in the 2007 housing crisis. We have been working on this for close to a year now, and as per the city attorney's direction, we have performed a mitigated negative declaration, has been complete, and the input from my constituents have been overwhelming. Whether it's the daily emails or the daily conversations I've had over the past year, it's been extremely clear that the neighborhoods in Council District 4 are overwhelmed by the onslaught of overscaled redevelopment of single-family homes. Today, I ask for your aye vote and support to bringing smart zoning to single-family neighborhoods. I would especially like to thank Councilmember Huizar and your staff for all your help on this item. Lastly, I'd also like to thank Vince Bertoni and the Planning Department, the City Attorney's Office for all your work on this ordinances. And thank you so very much, and I really appreciate your support on this matter.
Thank you, Mr. Ryu, Councilmember Ryu, and thank you for being with us here on this item. If we could have, we'll go to public comment, and then we'll see if our committee has any questions or comments. Nancy Segoyan, Mike Feinstein, and then Ronald Ziff. All public speakers in this committee have 1 minute to speak. Welcome.
Hi, Council. My name is Nancy Segoyan. I'm a 40-year homeowner in the city of Los Angeles. I'm a voter and a taxpayer, and I'm a concerned citizen. I'm here to ask your support and get a yes vote today to enact our ICO. Okay, because no matter what any builder or developer might say today or any other day, this is not about homeowners enlarging their homes. This is about developer greed. There is going to be still money to be made with homes that better suit the size of their lots. That's what we're asking for. There's still going to be plenty of money to be made. We just need homes that fit their lots. So the homeowners of Sherman Oaks are sick of seeing their neighborhoods destroyed, essentially being strip-mined by developers for greed. Okay, these people have owned their homes for 30, 40, 50 years, and all of a sudden a mammoth home goes up and destroys their property value and their privacy. I'm asking you please all to protect the citizens of Sherman Oaks and vote yes today. Thank you.
Thank you very much.
Hi,
Welcome.
my name is Mike Feinstein. I've been a resident of Sherman Oaks since 1971. I'm a police community representative as well. The mansionization has already started in our neighborhood, and homes are being torn down, and I don't want to wake up one morning and instead of looking out at the trees and the flowers, see a wall and someone looking into my yard when I have guests and family over. So I would appreciate a yes vote today. No delays, no postponements. Stop it now and reassess the situation. Thank you.
Thank you. Ronald Ziff,
Yes.
Dolores. Yes, after Ronald. Thank you. Welcome.
Okay. My name is Ron Ziff. I'm the first vice president of Sherman Oaks Neighborhood Council and chair of its land use committee. We held 4 public meetings on this issue. Prior to the meetings, about 20,000 notices were sent out, and over 250 people showed up to testify at each of the meetings. We heard from a multitude of residents, business owners, and developers, stakeholders. The overwhelming sentiment was to pass this ICO. It has the advantages of bringing clarity to the situation for both the city departments and the builders, and relief for the homeowners. Councilman Rue took up the issue. It's put in legal language, and the process can move forward. Planning Department and City Attorney have looked it over, and it's the Neighborhood Council's request that you do approve. Thank you.
Thank you. Dolores, Jolene Bell, Lisa Seidman, and James Cruz, or Cruss.
I'm Dolores Trujillo, resident of Sherman Oaks and a member of the Sherman Oaks Homeowners Association. I have been living in Sherman Oaks for 40 years, and through that time, the Planning Commission has not provided any parks for LA residents. We have the lowest of U.S. city park area, and now we are being overwhelmed with oversized buildings that are cutting off our light and the ground area around the houses. And I hope that the Planning Commission will try and preserve what we have and not cement over the area.
Thank you.
Hello, my name is Jolene Bell. I'm a homeowner in Sherman Oaks, and I urge you to vote yes today for the ICO. No more delay, please. We homeowners are tired of seeing our neighborhoods destroyed. I'm tired of seeing the trees destroyed and these McMansions going up and just covering us with walls. Please vote yes today. Thank you.
Thank you.
Hi, I'm Lisa Seidman. I live in Sherman Oaks. I'm a 25 years in homeowner. Anyway, I would like you to vote yes on the ICO today. Our neighborhood is unique. It has some historic houses on it on Survey LA, and we've also been able to talk to developers in keeping the bones of the houses, remodeling them, and they're still making their profit. So you don't have to build a McMansion in order to make a profit. So please vote yes today on the ICO. Thank you.
Thank you. James, Meg McComb, or McCullis, or Debbie Gagan. Welcome.
Hi, I'm James Cruz. I live in Sherman Oaks. I'm a homeowner. I'll be brief. I am in favor of the ICO, and I urge you to vote yes today. Thank you very much.
Thank you. So Meg, Debbie, and Roseanne Krikorian.
Good afternoon. My name is Meg McComb. I am the Vice President of the Wilshire Vista Neighborhood Association. I'm a resident, and I am with those members of CD10 and Pickfair Village who represent our concern and wish you to vote yes on our ICO. Will you all please stand? I feel that all of these people, along with the 500 people who signed the petition, which we circulated last June, support and concur absolutely with the people that have spoken before me from Sherman Oaks. We want our neighborhood to remain a neighborhood, not a development. Please vote yes today. Thank you.
Thank you.
Hi, I'm Debbie Gahn. I live in Pickfair Village, also located in CD10, and I'm going to ask my fellow CD10 residents of Wilshire Vista and Pickfair Village to remain standing. I am 5 days shy of celebrating 6 years of living in my neighborhood. And some people here are celebrating over 50 years in their neighborhood, in our neighborhood. And I say the word celebrating deliberately because we understand how special these neighborhoods are. Now, we all know the importance of character as it pertains to people. We teach our children character counts. It matters. It defines us. Well, character defines a neighborhood as well. It matters as a neighborhood, and it counts as a neighborhood. And we are here in full support of this ICO that keeps the scale and character of our neighborhoods in place so that we can go on celebrating the quality of life that our tree-lined streets and our 1920s and 30s houses give us. We thank you very much for supporting our ICO modeled after the Beverly Grove RFA. Thank you.
Thank you. Roseanne Krikorian and Elizabeth Carlin from Council District.
Yes, good afternoon. My name is Roseanne Krikorian. I'm a very long-time resident of Brookside. I I won't repeat what everyone else has said because it all applies even more so to Brookside, which is a neighborhood of homes built largely in the 1920s. I did want to mention one thing. At the last meeting of this committee in the fall, a gentleman who was opposed to the ICO, and I'm in favor, looked around the room and insinuated that the crowd, being largely senior citizens, were older people reluctant to change with the times and out of touch. I'd like to tell you that I've attended a good number of community neighborhood meetings on this issue in the evening, so that people who worked during the afternoon attended, and there are many younger people in the neighborhood, younger families, who support this ICO. Thank you very much.
Welcome.
Good afternoon, members, Mr. Chair. My name is Liz Carlin. I'm here representing Council President Wesson. I am here today to ask for your support in moving this ICO forward. I want to thank our stakeholders from Council District 10, Pickfair Village and Wilshire Vista. I want to thank the stakeholders from CD4, from Councilman Rue's district, who took the time to be with us in the middle of the day. I appreciate your time very much. I also want to thank planning staff and the city attorney for the work on this, and I ask that we have an aye vote and move this item forward. Thank you.
Thank you. Okay, so that completes public comment. Any questions or comments on this item? No questions or comments. We'll move to approve the ordinance as reviewed by the city attorney for form and legality and sent to full council. Any objections? Seeing none, so ordered. Thank you. Thank you, and thank you, Mr. Rue, for coming on this item. Thank you. Let's go to two quick reappointments, and then we'll move to item number 10. Item number 1, we could call that to order, please.
Item 1, Councilman, this is a communication from the mayor relative to the reappointment of Daphne Brogdon to the Central Area APC.
Welcome. Is Miss Daphne Brogdon here? Yes. Can you come up to the, oh, there you are. Welcome, and this is a reappointment to the Central Area Planning Commission. We want to thank you for agreeing to continue your service, and very active Central Area Planning Commission nonetheless because of the activity primarily in downtown and surrounding areas. And
Yes.
so you've all been very busy. Any insights, observations, comments about your reappointment?
Well, I'm very pleased to be reappointed. I've learned a lot, and I really enjoy serving the community this way. And I see the Planning Commission as a citizen oversight and the voice of the community, developers, all stakeholders. And so I'm looking forward to continuing that job.
Great, thank you, and thank you for volunteering your time. Any questions or comments for the reappointment of our commissioner? No questions, comments? We'll approve this item and move to full council with no objection. Thank you.
Thank you.
Welcome. One public comment card. I'm sorry. Doug Haynes. Doug Haynes. We'll hold this until we hear from public.
Just real quick, Doug Haynes. I'm on 2 neighborhood councils, East Hollywood and Hollywood Studios Neighborhood Council, and I got to say, we've all been tremendously impressed by Ms. Brogdon and the Central Area Planning Commission as a whole. So we look forward to her continued service and the service of the commission. Thank you.
Great, thank you. So we'll confirm this and move that item forward. Item number 2.
Item 2, Councilman, this is a communication from the mayor relative to the reappointment of Ms. Stevie Stern to the South LA APC.
Welcome, Ms. Stern. Ms. Stern, welcome. Thank you. Thank you for your service. This is also a reappointment. I want to thank you for your service and bringing your knowledge and activism to this commission, and anything you'd like to share with the committee.
Well, thank you very much for allowing me to be here. Thank you, council members and Chairperson Wizar. My last 2 years on the South LA Planning Commission has been interesting and challenging, and after spending 13 years as a founding member and president of my neighborhood association at United Neighborhoods Neighborhood Council, it has been really an honor to be able to serve my city on this commission. So thank you for your consideration for my reappointment.
Great, thank you. And any questions or comments for Ms. Stern? Seeing none, we'll move to approve and reappoint Ms. Stern to the South Los Angeles Area Planning Commission.
Thank
And
you
move
so
it to
much.
council. Thank you. No objection. Thank you. No public comment cards. We'll move on to item number 10.
Item 10, Councilman, this is an appeal that was continued from last week's meeting. The appeal is filed by Sylvie Shane. The appeal relates to the adequacy of the environmental clearance.
Thank you. Welcome.
Good afternoon. Thank you. Jenna Monterosa with the Planning Department. So as mentioned, this is a continued item from last week. The project involves the conversion of an existing vacant 18-unit apartment building into a boutique hotel containing a maximum of 24 guest rooms. The project has been approved for a conditional use to permit a hotel use in the QR4-2 zone, an adjustment to permit an existing non-conforming building setbacks, and a zone variance for off-site parking that the applicant has since then withdrawn. What is before the committee today is the appeal of the project's environmental clearance, mitigated negative declaration. At last week's meeting, we reviewed the appellant's appeal points, which related to traffic, parking, population, housing, and socioeconomic impacts. With regards to traffic and parking, planning maintains that the project did not meet any established thresholds to require any further analysis and was determined to not create any new significant impacts on the physical environment. With regards to the loss of housing and population, the requested application was filed in July of 2015 as a vacant building, with the last residents having moved out in October of 2013. That being said, the baseline for the city's review under the California Environmental Quality Act was a vacant building that had been removed from the rental housing market in 2013. The project did not meet the city's established threshold of significance of a loss of 25 or more multifamily rental housing units, and no significant impacts were identified during the environmental review of the project. As such, the impacts of the project will have on the physical environment have been vetted, and planning maintains that the project will not have a significant impact on the environment. With regards to the existing apartment building status as a rent-stabilized building and the previous enforcement of the Ellis Act, these issues are socioeconomic, and pursuant to CEQA Guidelines Section 15131, economic or social effects of a project shall not be treated as significant effects on the environment. That being said, during public testimony, questions related specifically to the manner in which the building was vacated under the Ellis Act were raised. Specific questions related to the legitimacy of waivers to relocation fees that were signed by residents in 2013, 2 years prior to the filing of the requested change of use to a hotel. Planning has verified with housing that 9 of the 18 units received relocation fees, and an additional 9 units signed waivers approved by housing of such fees. We return today with representatives of the Housing and Community Investment Department who will be able to speak specifically in the manner in which the subject building was previously removed from the rental housing market. We have today Anna Ortega, Director of HSID's Rent Stabilized Division, to answer any questions specifically related to this building that you may have. Thank you.
So do we have someone from HSID here?
Good afternoon, council members. Yes, well, basically, planning staff has accurately summarized what happened with this building at 1850 Cherokee. It was removed from the rental housing market in May of 2013 under the Ellis Act. At that time, the application was for a planned demolition in order to convert to condominiums. Usually, tenants in rent-stabilized properties that are being removed withdrawn from the rental market are entitled to relocation assistance, but there's a specific exemption when there's an application approved or on file for a condo conversion, which was the case here. There was an application in 2009. So the situation when we processed the ELLAs was that 9 out of 18 tenants had moved in between 2009 and 2013 and had signed waivers prior to entering into their rental agreements that an application was on file and therefore they would not be eligible for relocation assistance. So we carefully reviewed all of the documentation submitted by the property owner, and the Alice Act removal was approved in May. I understand that all of the units were vacated by October of 2013.
Okay, so thank you. So in terms of the Alice Act, the previous owner, did they follow all the rules with respect to the Alice Act?
Yes, they did.
Because I saw a note last week that not all the tenants had received the relocation assistance, but that was because, as you're stating now, that some of them did not qualify. But at least those that did qualify, they received their relocation assistance.
Yes,
Okay.
9 of the tenants received relocation assistance as required.
As regard, okay. And now, the new owners, would they be required to follow any outstanding responsibility by the previous owner with respect to the Alice Act?
That was all completed in 2013.
2013?
Yes.
Okay. So that was all the previous owner, 2013, and that whole process was completed back then?
That's correct, sir.
Okay, thank you very much. Now, ma'am, no, the lady standing next to you, Nikki, if I could ask you, when the people are speaking up here, if you could take the photos from the side. We usually don't allow people to come up here and... Okay, thank you very much. I'm just requesting that. Thank you very much. Because we have a number of other people who come up and obstruct us that way, so we have to be consistent with everyone who wants to come up while somebody else is speaking right behind them and take pictures. Where did my person go? Oh, my hate-seed person go. So any other questions or comments? Mr. Harris-Dawson?
Thank you, Mr. Chair. A couple questions on this project. So is there a distinction between the relocation responsibilities of a person exiting the rental business if they're going to convert to housing or commercial or hotel? Are there distinctions in their responsibilities to the tenants?
Yes. In most cases, they're required to pay relocation assistance, but there is a specific exemption when there's an application on file or already approved for a conversion to condominiums, whether they want to convert the existing units or demolish and build new units. So this case fell into one of those exemptions.
But in this case, they still met the regular relocation responsibilities.
I'm sorry, I didn't quite hear that.
In other words, so if I understand your answer correctly, the original proposal was for housing?
It was for basically a condo conversion.
So in that case, the responsibilities are different?
Yes. If the tenants receive notice prior to moving in that this application is on file or has been approved, the landlord may request that they sign waivers to the relocation assistance. So the ones that didn't get it had signed that type of waiver.
So I'm talking about now the ones who did get it. So of the ones who did get it, does it matter if it's is there a material difference between a conversion to a condominium or a conversion to a hotel?
If the plan is to convert to a hotel, then everyone would be due relocation assistance.
Okay.
That wasn't the case at the time it was processed in 2013.
So your understanding of policy is that it allows you to, on the one hand, provide relocation assistance based on it being a condominium. You decide not to do that later and you come back and do something else. Are you required to go back?
No. The removal took place in 2013, so there's no look-back provision.
So at the point you do it, you're good to go. You can move forward.
Yes.
Okay, thank you.
Okay, on a motion has been made, let me go first through public comment, and then we'll entertain that motion. Yeah, but as of courtesy, we're going to take it up again. Okay. Yes?
Adrian Corsani, City
Attorney.
Attorney's Office. So you did have the appeal hearing at the last meeting and public comment on the appeal. So today's public comment period may be limited to what new information was shared today.
Okay. So we could also just open it up as a courtesy, right?
Yes,
But
you can. It's a discretion.
By law, we are only required to say any new information that was presented today, that's what public can comment on. But
Correct.
As a courtesy, we'll open it up again and
That's
just
your
go through the
discretion,
public
yes.
comment card. Okay. Appellant Sylvie Shane.
Yeah, I just spoke to her. She has an emergency. She has to speak at the end and has the public comment go first before her statement.
I'm sorry, if she's not here, all I can do is call her name, and that's all I can do at this time. If you have more information, you could talk to my staff at the sidebar and see what could be worked out with respect to that.
Okay.
Thank you. We'll hear from the applicants. I have Dana Sales, can't make out the last name, and Michael Gonzalez.
Good afternoon, members of the Plum Committee. Dana Sales with 360. Very much appreciate you giving us another opportunity to speak. I've been working with this applicant on this project for the past year, which I think we clearly underestimated what seemed to be a fairly straightforward project for us. Just for clarity, the property owner and the applicant has been the property owner of the property for about 50 years, and he did put in a public comment card as well to speak. The ironic thing about this project, we heard last time, is that from the very beginning, our intention was to save this building and to save Cherokee, and to find a viable solution to a building that's been vacant. This project is no different than any other failed project that happened during the recession, where buildings either sat vacant or partially constructed and are being re-entitled and trying to find new life. The appellant's contention that the applicant acted in bad faith 3 years ago is just not true. The applicant not only spent hundreds of thousands of dollars on entitlements and construction documents for that condominium project with a prior development partner, they filed for and received a demolition permit for the building and acted for approximately 5 years from 2009 to 2014 to try and proceed with a condominium project. Unfortunately, there was no financing. The developer walked away, and that did not proceed. Every step of the way, we have been straightforward with the community about the intentions for this project. We know none of this RSO issues are before the Plum Committee, as they are housing issues, but it's really important that we try to clarify the things we did not have an opportunity for. Lastly, last week you heard from several people in the community, including prior building manager, prior tenants, that they were forced out of the building, that they were coerced, that they did not receive relocation. Several of the people who did testify lived here rent-free. One of the tenants was given not only relocation assistance, but coerced the building owner into additional funds above and beyond. The prior building manager not only lived in the building rent-free, received a full salary, and also received relocation, which is an express exemption under RSO that someone that lives in the building that manages and receives a salary is not entitled. The owner has gone above and beyond as a matter of both good faith, letter of the law, and just frankly human decency. This project is no different than any other adaptive reuse project in the city, giving second lives to old buildings. Our team has worked really diligently throughout this project to define operational restrictions for the community to allow a viable, non-intrusive use into the neighborhood, to offer a legal lodging alternative in a sea of what is considered to be one of the hub of the short-term rental Airbnb debates. There's other buildings on Cherokee Avenue that are kind of the epicenter of this issue. The property owners tried to do everything by the book so that we proceeded in good faith from the very beginning. The entitlements that the project received are consistent with all permissions granted in the zoning ordinance in compliance with CEQA. And for that, this project has been approved and the appeal has already been denied once. For all of this, I respectfully urge you to deny this appeal. While the Ellis issues are before you today, while the Ellis issues are not before you today, only the CEQA is. The applicant has complied with all legal and regulatory Ellis requirements and has treated all tenants in good faith. For that, thank you.
Thank you.
Good afternoon, Mr. Chair, council members. Michael Gonzalez representing the applicant. I want to refocus the call of the question today. It's about whether there is a fair argument in the record supported by substantial evidence that the CEQA, that there was a substantial impact on the environment. Everything before you today, even things that were submitted as of today, are policy documents, are the city's guidelines, none of which rises to the level of substantial evidence to support any significant impact on the environment. I remind you that the baseline started with the vacant building for this 2015 project. There were no tenants inside the building. The city's screening criteria is removal of 25 units from the housing market before an impact analysis even occurs. The call of the state law is whether the removal of housing will necessitate construction of new housing, creating a physical impact. CEQA is about physical impacts, not the study of social and economic ones. Those can be considered if there are physical impacts on the environment. The law is very clear on this point. I just want to remind again that the question today is whether there's a fair argument supported by substantial evidence of an impact. Thank you.
Thank you. George Abrams, Doug Haynes, and Sean Chandra, 1 minute.
Yeah, the applicant in his June 27 communication said that the developer and partner is ready to proceed with the condo development of the hotel project, does not move forward. There's absolutely no possibility of the condo project ever being built. The Hollywood quadrangle of the Alquist Priola map show the Hollywood Fall projecting directly through the project site. Structures for human habitation, except for the small wood frame structures like the type currently on the site, are explicitly prohibited by the Act. Former tenants of the building witnessed a geotechnical investigation being conducted in the vicinity of the project last year. However, no investigation report has ever been submitted to the grading division of the LADBS. If there was a geotechnical report exonerating the project site of being directly over the Hollywood fault, it would have been publicly released. And the condo project is simply an empty threat.
Thank you. Doug Haynes, Sean, and Travis Wester.
Hi, my name's Doug Haynes. I just want to clarify a couple statements that were made last time. I didn't speak, but as a former board member of Hollywood Heritage did not write a support letter for this project. What they have is a preservation agreement with the developer, and that's it. Hollywood Heritage has never come out in support of development. It will not come out in the future in support of any development. It only has preservation. Also, the demolition permit that was stated was the previous development of a condo conversion. That expired this year, so it's no longer in play and it shouldn't be brought up as a factor. Thank you.
Thank you.
Good afternoon. My name is Sean Chandra. I'm a housing attorney representing LA tenants for the last 8 years. I'm also a tenant myself. I live and rent in Gil Cedillo's district. And what I've seen on the ground in my neighborhood and in the courts is a tragedy of epic proportions. It's causing a groundswell of anger and desperation. And what I want to specifically address from the CEQA standpoint is that the threshold of 25 units is irrelevant in today's age. I think that was established more than 10 years ago, that CEQA threshold. And in today's housing crisis, I think that threshold of 25 units to establish that a project has a significant impact on population and housing needs to be re-examined, and it should be re-examined before this project can go forward. Thank you.
Thank you. Travis Wester, Mark Lipman, Ellery Jane.
Hello, my name is Travis Wester. I'm a tenant in Hollywood. I live right down the street from Cherokee, right down the street from this property. We have a terrible homeless problem in Hollywood, and projects like this aren't making it any better when they're kicking people out on the street. It's my understanding that tenants who entered this property between 2009 and 2013 might have signed a waiver. My question is whether or not they signed that waiver for a condo project or a hotel. If it was a condo project and they're turning it into a hotel, my question is how come they didn't get a relocation fee? It's relocation fees that keep people off the street, and that's not what's happening in Hollywood right now if you walk down the street. Thank you very much for your time, and I look forward to you supporting this appeal. Thank you.
Mark Lipman.
Hi, good afternoon, Mark Lipman. I'd like to get a clear definition of what physical impact means. Because when a person is evicted from their home and they physically impact the sidewalk because they become homeless, that affects our community. When people are being driven out, when seniors and disabled people are being pushed onto the street through Ellis Act evictions, and you guys do nothing except deadly silence when we need you the most, that's a physical impact on all of us. And we need you to actually show some courage and stand up for the little guy, because you know what? We all know you're in the pocket. But the question is, are you in the pocket of the people or of the developers? Because if you're in the developer's pocket, then please get out of the public seats that you're taking. Because we need people who are really going to stand up for the little guy. It's not about money. It's about people's lives. Thank you.
Ellery Jane, or I can't make out the last name. Shauna Johnson.
Hi,
and
thank you.
Donald Ryan.
Good afternoon. My name is Ellery Jane, and I live at 1843 North Cherokee. My neighbors and I are concerned with the pattern of converting rent control units into commercial projects. I have met with Councilman O'Farrell personally, and though he has admitted that this deal, it was a shady deal, no action has been taken. O'Farrell has stated that his concerns were with preservation of this building. However, it was then discovered that this building's demolition permits have expired. While no one can force the owner to convert the building back to residential one, the city can limit options as to what can be done with the building. Considering that many previous residents of 1850 never received their relocation benefits as legally required, the legal standings of the current hotel project are questionable and may invalidate any current contracts made. As a resident who lives across from 1850, I am concerned with issues relating to traffic, noise, and safety, especially with the youth and senior centers on the street. I ask that this project require a full environmental review to overlook all of the issues at hand before proceeding with the project. Please support the appeal. Thank you.
Good afternoon. My name is Shauna Johnson. I live in Council District 13 at the Yucca Argyle Apartments. This is a 40-unit rent-stabilized complex, home to seniors, veterans, and working-class families. Like the displaced Cherokee residents, we are facing imminent eviction, so Champion Realty can tear down our apartments to replace it with the 15th hotel and the 11th luxury apartment complex within a 1.5-mile radius. I came here today to ask you to support the appeal of 1850 Cherokee so that the city and the developer can identify the impacts that this project will have individually and cumulatively on homelessness and the loss of housing stock. With the current crisis-level shortage of affordable housing and homelessness at epidemic levels, we can't keep losing rent-stabilized buildings and displacing longtime residents of this stable and diverse community. Please support this appeal. Thank you.
Donald Ryan, David Lesser, Annie Gagan.
Thank you very much. My name is Don Ryan. I'm a resident of Hollywood. I've been to multiple meetings to talk about the Cherokee Apartments, and I understand that what's before you right now has to do with the parking situation for the building, but you can also understand as residents of Hollywood, we're freaked out. We're freaked out that there's the possibility that people could be displaced under one claim and then a different kind of project can move forward, and we can then talk about the vacant building without recognizing what has been done. I understand for the developer, there's a feeling that that's all in the past. But again, as council members, you all understand that for us, it's not in the past. We're living with it on a daily basis. I would please urge you to vote to support the appeal. Thank you very much for your time.
David Lesser, Annie Gagan, George McCowan.
Good afternoon. My name is David Lesser. I'm the property owner at 1850 Cherokee. Just to clarify quickly for the record, I know it's not at issue, but there was just some previous public comment about Alquist Priolo. Recently, there has been trenching done at 1846 Cherokee, the lot immediately to the south, and the lots immediately to the west, and both have been cleared of any seismic issues. And we've been told that because of that, our site also has no seismic issues. But I wanted to talk to you briefly about how I got to where I am in this project today. My grandfather, who was a career real estate investor and developer, purchased this property over 50 years ago. It's been in our family for over 3 generations. When he passed away in 2007, my father and I both had essentially no real estate experience, yet we were now left in charge of Cherokee and one other apartment building. As we were weighing our options, a developer who I had a prior relationship with knew our situation, approached us with a concept for the 39-unit luxury condominium project.
Thank you.
Thank you.
Annie Gagan, George McCowan, Mark Simon.
Hi, I'm Annie Gagan. I'm a 35-year resident of Hollywood. I support the appeal. I live in the neighborhood. I'm part of the neighborhood council that voted. We were brought on, the Plum Committee voted 4-2 against it. We were then orchestrated to have a tour of it. At the time of the tour, we were told it would be either this project or tall condos. Then we found out it was on an earthquake fault line, and that wasn't true. We were never told that people had been thrown out, and some wound up homeless. They appeared at our neighborhood council meeting and spoke. 18 rent-stabilized units disappeared. Potential loss of a residential neighborhood. Loss of homes, separation of families, people living in cars and on sofas. Good God, what does it take for you to wake up? I commend Council Members Cedillo and Harris Dawson for seeing the bigger picture here. I regret that some people, like Council Member Mitch O'Farrell, will not see the bigger picture here. What is our culture coming to? SECRA protects our wildlife. No significant impacts? Tell the U.S. Vietnam vet who got thrown out and had to be separated from his children and wound up homeless that there's no significant impacts.
Thank you. George McCowan, Mark Simon, Luis Saldivar, and Heather Fox.
Hello, I'm George McCowan, and I lived at 1850 Cherokee in apartment number 1. Pretty much, it was just a rough thing to go through, signing the waiver and not really necessarily knowing what I was agreeing to. Just, yeah, it's a struggle. And my dad lived in the building too. His name's Albert McCowan. He's the veteran. He's struggling still after all of the stuff that he's been through. Being in the unit while they chipped off the paint of the building, sanded the building. I don't know what kind of health effects I'm going to have in the future from living with that. But
Can you speak up, please?
Is that better? Okay. It's just a struggle. I've been struggling pretty much ever since I got out of the building, and my mom let me stay with her for a while. And I finally found some kind of affordable housing, I guess last year, that's suitable and similar to that.
Thank you. Mark Simon, Luis Saldivar, and Heather Fox.
Hi, Mark Simon. I represent the LA Tenants Union and the Rodney Drive Tenants Association. We were a group of 12 tenants who were evicted, Ellis evicted from our building last year. And once again, the impacts on the neighborhood are just too huge to ignore and say there's no impact on the neighborhood. Again, coming down here, I took the subway down here, there were at least 5 homeless people in the one subway car that I took down here. Evicting people from this building is not going to help matters like that. And I also resent calling this a vacant building. It's a vacant building because the people were evicted. It was not a vacant building. It was a building from which 12 or how many people were evicted. And it also sits on a fault line, which wasn't addressed at the last meeting last week. I'd like to see that addressed by council. Thanks.
Welcome.
Good afternoon, Chair, members. My name is Luis Aldivar. I was born in Hollywood, and I am a resident of CD 13. I'm a father, first and foremost. I am also a member of HUNC, YADA, ACA, and the LATU. I am asking you to please hear the voices of the local community and to stand with your constituents, not the developers. How do you expect your constituents to believe that you care about preserving rent-stabilized and affordable housing when you are considering the proposal of this project at Cherokee? I am asking you to support this appeal, and I am here to put you on check, Mitch O'Farrell. If you want to get reelected next year, you better start representing the people who elected you.
Heather Fox, Walton Centerfit, and Damien Goodman.
I'm going to repeat my statement from last week since you guys were on your phones last time. Thank you. My name is Heather Fox. I am here on behalf of the parents of Canyon School Co-op at 1820 Las Palmas, which is 1 block away from Cherokee. And we are extremely concerned with the increasing transient population in this neighborhood. There are many facilities nearby that rely on a stable community, such as the Canyon School, the Las Palmas Senior Center, the Yucca Community Center, the YMCA, the Public Library, Hollywood High School, and more. This neighborhood does not need more hotels. It needs affordable housing for the permanent residents who rely on these services. By continuing to push these residents out, these much-needed facilities suffer. Mayor Garcetti proposed a budget of $138 million to fix the homeless problem, while at the same time ignoring the eviction of 22,000 RSO units since 2000, including veterans, artists, teachers, students, elderly, and disabled. And instead, you continue to support luxury housing and hotel conversions. This is a backwards way of running the city. Please. Thank you.
Walter Centerfit, Damien Goodman, and J.T. Lawson.
Hi, I'm Walton Centerfit, a tenant, a resident of Mr. Huizar's district, having been evicted from Mr. Rue's district under the Ellis Act. I'm also a public health epidemiologist who studies the adverse impacts on the health of our individuals, our families, and our communities of homelessness and of housing burden. You have the opportunity to use this appeal to do the right thing. They may have legally complied with the technical aspects of the law, including the Ellis Act, but clearly they have devastated the lives of the 18 tenants and more who have been evicted. This is happening all over the district, including in ours, Mr. Huizar. And if we don't make it more difficult for people to follow through with highly profitable plans that require entitlements and special zoning from the city, then these kind of use of the technically legal but morally offensive devastation of our community will continue. So do the right thing. Use the legal authority you have now to take a stand and support this appeal.
Thank you. Damien Goodman, J.T. Lawson, and J.T. Lawson after Damien Goodman.
Good afternoon, council members. Damien Goodman of the Crenshaw Suburb Coalition. We're here on another issue, but I felt it incumbent to speak on this tragedy. So formally, we first like to join in all comments within the public record in the council file in opposition to this project, and in the public record and formally ask that you support the appeal. Council members, we're on the list of problems and challenges of the city of Los Angeles. Does absence of boutique hotels in Hollywood rank? I read about homelessness. We appreciate your actions in that endeavor. I read about the lack of affordability in our city. So we're concerned about the precedent that this sets throughout the city, and we'd ask you to use whatever it is in this council's power to prevent this tragedy from continuing. Make these tenants that were illegally, so what it sounds like, just kicked out of their apartments whole, and address the broader issue of an absence of affordable housing, the limited amount of rent-controlled units within our city, so that this can be a city for all. Thank you.
Thank you. And the appellant has arrived, Sylvie Shane.
So she's speaking after me or before me?
You are J.T. Lawson?
J.T. Lawson, yes,
Yeah,
former tenant and manager of the Cherokee building in question. I would like to speak to the character of the developer. His team seems to think that that he's a sympathetic person and they speak on his behalf. He was not sympathetic in the whole process. He treated people with total disrespect. There was, in speaking to my staying there afterwards, it was totally for their benefit. They got somebody to watch over the building, make sure other people didn't move in, and they also disconnected the gas while I lived there. Kind of forgot that I lived there. So there's no... developers like this, which sadly, he's not the only one. He's a small fish in a bigger ocean that I've seen during this process, where they are talking for the community, but most of the community is displaced. So the people they're speaking for, that they say they're coming in to make a difference for, don't exist there anymore. Their idea of community is a fantasy. And there's no proof that you guys are asking for that they are speaking for the community, like a survey or something. Thank you.
Thank you. Now, Sylvie Shane, the appellant, has arrived. Welcome, and you have 5 minutes.
Thank you very much for the opportunity to speak. Honorable members of the Plum Committee, last Tuesday, the 3 present members of the committee, Council Members Huizar, Cedillo, and Harris-Dawson, heard the CEQA appeal of 1850 Cherokee, where the tenants were evicted in 2013 by the Ellis Act under a previously entitled condominium project that never moved forward and for which the property owner benefited from a relocation waiver that would not be applicable to the project that is currently before you. As the appellant, I have based my arguments strictly on the inadequacy of the environmental review for this project, on the grounds that the adopted MND did not identify or mitigate potentially significant adverse effects on the environment as required under CEQA law, an argument supported by substantial evidence. Public testimony reflected a wide range of issues, some that were personal and more anecdotal for the people who used to live there, and much that supported the context of the CEQA arguments that I made. The applicant's representative yesterday submitted a rebuttal letter aimed at discrediting those personal experiences and reducing the significance of the issues raised during the hearing. One of these attempts is with respect to the relocation waivers that were much talked about. In order to further correct the record that is being distorted by misleading information, I want to refute some of the claims being made with respect to the relocation benefit waivers. The applicant contends that a third of the tenants were there less than a year. That is false. What the applicant is not telling you is that there were certain tenants, including Jesse Cilio, James Moriarty, and Max Blond, who moved from one apartment to another during that time, but had lived on the property for far longer. In fact, Max Blond, who is here to testify, I hope, lived at Cherokee for a cumulative total of 9 years and yet received no relocation money. I've submitted copies of the waivers that he was asked to sign, 2 different waivers supporting the evidence that people were in fact moving from unit to unit. The applicant states that in exchange for the waivers, tenants received below market rates. However, the rents of the waived tenancies were in line with those of existing tenants, depending on size. Cherokee provided below market rates across the board probably had more to do with the condition of the building, which lacked upkeep. While there exist a multitude of issues with how this project came about, what is before you is a challenge on the environmental review of the project, and the whole of my challenge is based on CEQA. Although housing and displacement may cause economic and social changes that in and of themselves are not considered significant effects on the environment, the impact of displacement is causing other direct and indirect environmental impacts that are having significant adverse environmental effects. Homelessness is a significant environmental effect. So much so that the City of LA declared a state of emergency in homelessness in September of 2015. A state of emergency is by its very definition a significant adverse environmental impact that requires city agencies to concentrate resources and effort to address and resolve. Given the current conversations that have been had in City Council to address the impact of homelessness, it is a fair argument that homelessness continues to be an issue, one that the city has not resolved and continues to spend time, effort, and countless resources in addressing. Just last week, the City Council discussed the possibility of banning the homeless from sleeping in cars due to the public safety and significant adverse environmental impact this is having on surrounding residents. 2 former residents of Cherokee are homeless, with 1 now living in a vehicle. How is this not the definition of a direct impact or a fair argument? And if this is not a significant adverse impact, then why does the city feel the need to propose a policy to ban it? I challenge you to take the position that having to step over and around a homeless person, tent, or encampment on our city streets is not a significant environmental impact. We know that homelessness is increasing, and we know that affordability is tied to it, and yet the city is failing to meet its requirements under CEQA to identify these impacts. I've submitted a Sustainable Communities report that's called The Case for Housing Impacts Assessment, the Human Health and Social Impacts of Inadequate Housing and Their Consideration in CEQA Policy and Practice. And I've highlighted pages that are important to the argument that I'm proposing. Economic and social changes resulting from a project shall not be treated as significant, but economic and social changes may be used, however, to determine that a physical change shall be regarded as a significant effect on the environment. Where a physical change is caused by economic or social effects of the project, the physical change may be regarded as a significant effect in the same manner as any other physical change resulting from the project. Alternatively, economic and social effects of a physical change may be used to determine that the physical change is a significant effect on the environment. Homelessness is a physical change to our environment. Neither direct nor cumulative impacts of this project have been adequately identified or mitigated.
Thank you, Ms. Shane. Your
Please
time is
support
up.
this appeal. Thank you.
Thank you very much. Okay, I have a question. I have a question for our HSID person. And again, what's before us is the sequel appeal, although we've discussed a number of issues related to the Alice Act. But one of the public speakers brought up an interesting point, which is if the original application for change of use was to go from an RSO unit to condos, there are certain rules and regulations that go with that, right? But then they decided not to do condos, sold it, and now a hotel is proposed. Under those circumstances, do we still apply the rules and regulations under the condos or a hotel?
The Ellis withdrawal was completed under the rules in effect in 2013 for the condo conversion.
I get that.
Right.
And certain rules and regulations were used for that.
Right.
So now hotel is proposed, but we still followed the Ellis Act under the condo rules and regulations.
Because the Ellis Act removal is completed already, the tenants have vacated. So that process was followed through and completed in October of 2013.
Okay, and generally speaking, would you say that there are, it's hard to describe, but lighter rules with respect to tenant relocation and assistance under a condo conversion than there is for a hotel?
Well, there's only one exemption, and that's for the condo conversions.
Okay.
So yes, they have the possibility of a waiver for relocation assistance.
I see. So they benefited from the condo, the application for condos, but now different uses going there. Now, is that, we follow that because of the Ellis Act, which is a state law, or is that under our own ordinance that we can change about other circumstances like this?
It is in city, it's in the city LAMC.
So we could fix that by changing our own ordinance that if somebody proposes a condo conversion and then in the future they do a different use, there's got to be a significant time lapse before they could, it needs to elapse before people take advantage and get the benefits of a proposed condo conversion and then do something else later. Can we do that?
Potentially we could amend that RSO exemption, yes.
And that's our ordinance, it's not state law?
Yes.
Okay. Thank you. Any other questions or comments? Mr. Cedillo?
Mr. Chair, thank you for those questions. I think, I'm not going to be presumptuous, but I think you're on point here. I would say to you that the Ellis Act is not completed because the Ellis Act was set up, first I'd argue the Ellis Act is set up to protect tenants, right, through this ever-changing market that we have. But I would say to you that the Ellis Act was not completed because it was designed to compensate tenants when, in this case, the landowner wanted to stop being a renter and wanted to move to condos. And so therefore, until he built those condos, this process wasn't completed because it's envisioned that he's taking advantage of this process to move tenants out of the building because he's going to build these condos. The condos were in fact not built. That's undeniable. So whether it's some passage of time or not, as you indicated, really is not relevant. The fact of the matter is, whatever his purposes were at the time, he attempted to utilize the Ellis Act to remove tenants, and then at the end, we are here to talk about permitting a hotel to be built. So it goes from, I'm not going to ask the tenants to move out, I'm going to use this law called Alice, I'm going to remove them, but I'm not going to build the condos, I'm going to sell the property so a hotel is built. That's not the purpose of Alice. It's a frustration. I don't want to say it's a bait and switch, but it clearly is the product. The final product is that the tenants aren't receiving the remedies that were due them with the execution of the Alice provisions. And so that's what's before this body. Did the tenants receive the protections and the remedies that were due them under Alice? And clearly there's no sense that Alice was envisioned to remove tenants to build hotels. There are other remedies for that. There are other procedures for that. That's simply not what was envisioned, and that is, in fact, what took place. The sequence, as you say, is impacted because there was some passage of time, but the passage of time, frankly, is not relevant with respect to the protection of tenants' rights.
I think Mr. Cedillo brings up an interesting point in that under our current rules, the housing department is telling us that the Ellis Act has been complied with, correct?
Yes.
I mean, you started off by saying that. But if you take Mr. Cedillo's point of view, we have not satisfied the Ellis Act because we used the rules and regulations applied to a condo. This is not a condo. This is a hotel. So therefore, the new owner should have to compensate at the rate and provide relocations assistance at the rate of a hotel and not a condo. So any response to that?
I think the council could put conditions on the change of use. The Alice Act is about withdrawing the property from the rental housing market. So it could be for any number of things. The only one that gives an exemption from the relocation is condos, but you can also withdraw them in order to convert them for a hotel. So they could have filed in order to remove them to convert them to a hotel. The difference would have been that then they would have had to pay relocation to all of the tenants.
Yes, and so what I'm having difficulty here understanding is that under our rules, what exists before us? You're saying they've satisfied the Alice Act, but what is being proposed is to say, would you agree or disagree that the Alice Act has not been satisfied because it's a different use now? It's not the condos. Can that argument be made under our rules?
I would have to say that the units were withdrawn in 2013. All of the relocation that was due under the application at that time was paid, and they were vacated by October. At the longest, the Ellis could have gone on for a year after, because sometimes tenants are entitled to an extended stay. In this case, none of the tenants requested an extended stay. So 4 months after they filed for the Ellis, the units were vacated. At the point where they're vacated, they've been withdrawn.
Okay. Mr. Harris-Dawson and then Mr. Fuentes.
Thank you, Mr. Chair, and thank you to all my colleagues for engaging in this discussion, everybody that's come to be a part of it. It appears to me, and I would love to hear HSID's and perhaps the city attorney's comment on this. It appears to me, as I understand the information, the letter of the law was met in this case. The policy was complied with on every front. But I think you can see us struggling with the sort of moral hazards you create when you say to the world, this rule only lasts for a year. And if you can wait it out, you can do whatever you want to do. And you're not subject to the spirit of the law. And so I'm just wondering, do I have a misreading of that? Are is the current policy such that we can expect more and more people to come in and do this?
Adrian Corsani, City Attorney's Office. So I think that what's been highlighted here is the way that the RSO ordinance is written. And so City Council could request a policy change to be made, and that could go through the process. But I think based on what the presentation of the facts were in this case, if similar facts occurred, you might have a similar result.
Mr. Fuentes?
Thank you, Mr. Chair. You know, I think that you raise a salient point on our ability to be able to change our municipal code to better conform to the points that Mr. Cedillo and Mr. Harris-Dawson are making in terms of the time lapse that would have to go before there were any incentive to bait and switch, as it were. So I think Mr. Huizar, you're absolutely right. We have our work cut out for ourselves, and hopefully Mr. Cedillo will champion that in your committee. The question I've got for the City Attorney's Office, I think Mr. Cedillo raises a very interesting point about the opportunity to condition the project to apply and I'm concerned about this, it's an ex post facto sort of application of the law here, to apply the standard on the hotel now that we don't have condominiums. Do we have what authority would we use to make those findings?
So the Adrian Corsani City Attorney's Office, the CUP was already approved. There's no appeal of that available. Right now, the only matter before the committee is the CEQA appeal, so there's no opportunity to condition that conditional use permit.
Okay, so I think, you know, Mr. Harris-Dawson, you said it best. I mean, the color of the law, at least as presented by the Housing and Community Investment Department, the City Attorney's Office, and the Planning Department staff, is that it has been satisfied. But the opportunity here, colleagues, is to figure out how to remediate the municipal code going forward so that we have our process so we don't have situations like this. So, Mr. Chair, I would just ask that we entertain the motion that I made earlier, denying the appeal, accepting the findings on the CEQA and the mitigated negative declaration.
Okay, so there's been a motion to deny the appeal.
Last comment. Last comment.
Oh, you have comment? Okay. Mr. Cedillo?
Mr. Fuentes is absolutely right. We're struggling with the letter of law and the spirit of the law. We could go forward, and I'm going to say this, it's gratuitous, but I'm going to say this. We are grappling to find justice within the framework of what the laws are that we have. Every man here is committed to addressing issues of homelessness. And if you don't believe that, you look at what they did this morning. The first city in the nation to commit over $1 billion to address homelessness and over close to $250 million to address affordability. That's the commitment of the men that are here. So we are grappling with this each and every case by case. There's a suggestion that we go forward and there's a policy that then we can construct to make sure this doesn't happen again. But let me suggest to you that we, Mr. Chair, maybe there's an opportunity for a hybrid here so that we use this case as kind of the case for which then we build the policy. In this case, we say that we've looked at these facts. We recognize that while the letter of the law may tell us that we're required to do one thing, that the spirit of the law is that there's a remedy due here for the other tenants, and that we fashion out the remedy for the other tenants while at the same time moving forward with what we believe the rule of law requires us to do. So it's kind of deny in part, grant in part. And maybe our able city attorney can fashion that for us.
I wasn't sure what the motion would be, but there is a motion that we needed to entertain first, which is Mr. Fuentes's. And let's work on that motion, and then if that should succeed or fail, then we go to second for Fuentes' motion. Yeah, there's been a second for Fuentes' motion to deny the appeal on the sequel appeal. That's the only thing before us is a sequel appeal. Any objections to that?
I think the chair, the council, you have a comment to make?
Mr. Chair, Mr. Cedillo, I'm taking a vote here on the first motion. So, oh, okay. Okay, Mr. Cedillo, Mr. Cedillo walked in late on the to the meeting. This is a, what do you call that? What type of hearing? It's
Yes, this is a hearing on an appeal, and so the hearing had started before Mr. Cedillo arrived, and therefore my recommendation is that Mr. Cedillo not participate in the vote, and since there is no abstention, Mr. Cedillo may leave at this time if his vote is not to be recorded.
Wow. Okay, and for future purposes, when we have these types of situations, can that individual also participate in the discussion?
The participation, if the council member is offering comment and similar to other council members who may attend the meeting, that would be sufficient.
Thank you. So on the question to deny the appeal, the sequel appeal, there are no objection with those council members present? So ordered. Thank you. Thank you. Next item. Next item, number 6.
Sure. Item 6, Councilman, this is a City Planning Commission recommended and City Attorney ordinance relative to second dwelling units in the city.
So if you could talk to the clerk, please.
Blocked my choice from talking. I gave him a card and I never got a chance to speak.
Okay.
No, I didn't. I brought it in. I never got a chance to speak. I'm one of the tenants in the building.
Thank you. Item number 6, please.
It's item 6, Councilman. This is a City Planning Department and City Attorney prepare ordinance relative to second dwelling units.
Staff here on this item, welcome.
Yes.
Good afternoon, council members. Matt Kolesny, City Planning Department. I don't have a lot for you. This item was before Plum 2 weeks ago. We got a full presentation from my colleague Claire Bowen. This item was sent to City Attorney's Office for form and legality. That has taken place, and now the item is back before you. City Attorney is here to answer any questions. I'm happy to answer any questions for you.
Thank you. We heard this item before. This item is now back for us with the ordinance. Draft implementing ordinances. No, I'm sorry. Yeah, it's the ordinances. And so we'll go to public comment now. Lynn Kuwahara, Barry Johnson, Len Judican, and Daniel Friedman. Welcome.
Hi. My name is Lynn Kuwahara. I'm a CD10 resident for 50 years. I'm just asking that you please slow down this process and to think it through, give more consideration to the thousands of homeowners that will be affected by repealing this ordinance. It's for a few dozen people who proceeded ahead with their projects, even though they were warned that this might come up. We're all being affected. This council is bending over backwards, I feel, for them, and that the residents will have no protection after this, if it's allowed to stand. I'm sorry. Thank you. Thank you very much.
Barry Johnson, Studio City Residents Association.
This isn't the first time a state law has trumped one of our ordinances. We were screwed with 1818, having 56-foot high apartment buildings built in the backyards, virtually, of single-family homes. I feel this time we need something to replace the ordinance that's being repealed. And until you have a replacement ordinance, we shouldn't be repealing anything. We need to respect the integrity of single-family home neighborhoods, and we are not doing that in this city. And again, one size does not fit all. Thank you.
Thank you. Len?
Excuse me. My name is Len Judakin. I spoke before the last hearing explaining that for reasons of being close to family, for health reasons and others, my son and we made the application for this unit. This week, more than any other, is really proof of what I said last time. I've been unbelievably sick and indisposed and been way away from them and not had the contact or the support that I should have. Just to conclude, we have the only permit that was not put on hold but was revoked. And I'm just hoping that the ordinance which I have seen, that our permit will be reinstated under the grandfather clause. Thank you.
Thank you. Daniel Friedman?
Hi, good afternoon. My name is Daniel Friedman. I'm an attorney with Jeffrey Mangels, Butler Mitchell. I actually represent that gentleman right there, Len Judakin. We've been working with him in the city closely to try and resolve this situation. I would like to briefly I actually would like to speak to the people here who have come in to oppose and just let them know that they are being duped, that they are trying to oppose this committee and this council from complying with state law. And for those who are thinking they're not trying to encourage the violation of state law, they seem to be encouraging the council to adopt a particular solution. Now, it's curious, this particular solution also allows for second dwelling units, but it just happens to be this particular solution they want seems to be particularly advantageous to one gentleman who sued the city on Memo 120 because of his neighbor and a specific guest unit next to his house. This is NIMBYism on steroids. This is about Carlisle Hall's house and protecting his backyard, and I want to encourage the council and this committee not to bend to NIMBYism gone astray. Thank you.
Great, thank you. And we did receive a card after public comment had begun, and we have a policy in this committee that we do not accept public comment comes after public comment has begun, so that would be noted and filed in the record. Thank you. Any questions or comments on item number 6? Seeing none, we will move then to approve the final ordinance and send to full council. Any objections? Seeing none, so ordered. Thank you. Item number 9. Is there a council date on the ADU? I'm sorry. Is there a council date on the ADU?
Tentatively for July 26th.
When?
I'm going to try to schedule it for July 26th.
July 26th? July 26th.
That's tentative.
Okay, thank you. Item number 9, welcome.
Sure. Councilman, item 9, this is a report from the Planning Commission. It relates to amendments to the West Adams, Baldwin Hills, the Mart Park Community Plan, as well as a zone change, a high district change, specific plan amendments, and the CPIO.
Good afternoon, council members. My name is Connie Pelini-Tipton on behalf of the Department of City Planning. I'm pleased to introduce the West Adams, Baldwin Hills, Lamert Community Plan for your council consideration today. We were here earlier this month to present this item, so we'll be focusing on a recap. I'd like to take a brief moment to underscore the importance of your actions today in approving the West Adams Community Plan update. This update is particularly, I believe, answering Councilman Harris Dawson's inquiry earlier. So this is a community plan update. It's one of 3 community plans that we have updated in the last decade. So this has been and represents a tremendous amount of effort and some delay. So we really appreciate having the opportunity to be here in front of you today. Again, these plans are vital for directing the future of Los Angeles's communities. So we look forward to bringing you future updates. And now I'd like to invite Ruben Caldwell to present the plan for your consideration.
Thank you.
Good afternoon, committee members. Ruben Caldwell with the Community Planning Bureau. As the committee will recall, at your June 7th meeting, a few modifications to the new community plan were considered and referred back to the City Planning Commission. These changes involved retracting in part zoning recommendations for 2 sub-areas of the Jefferson-La Cienega TOD, updates to the policy document, as well as revisions to parking and residential use limitations within Leimert Park Village. These changes have been reviewed and were unanimously approved by the Commission at the June 23rd public hearing. Today, we request the consideration of the West Adams Baldwin Hills Leimert Community Plan update in its entirety. As a quality of life plan, the primary goal of the new community plan will be to regenerate complete and sustainable neighborhoods where access to a variety of goods and services, quality jobs, and resources are once again made available to community residents within walking distance of their homes. Through adoption of the Community Plan Implementation Overlay District, or CPIO, and amendments to the Crenshaw Corridor Specific Plan, pedestrian and transit-oriented development regulations will be activated, which call for quality new development designed in a manner that is respectful of historic development patterns, all while seizing upon the unparalleled opportunities afforded by both the Expo and Crenshaw LAX lines, which will feature a total of 10 stations serving the area by 2019. Now, it is important to note that today's action to approve the community plan update will involve forwarding the ordinances to the city attorney for form and legality review. The ordinances will return to this committee once this review is complete, and the city clerk will be instructed to publish these ordinances concurrently. To conclude, once again, I'd like to thank the many community members, council office and department staff who have participated in the development and completion of this plan. The community plan before you today seeks to strike the balance in responding to the many voices of the community and puts forth a roadmap guiding all manner of land use decisions in shaping a preferred future for this community. Thank you.
Thank you. We'll go to public comment now. Gwendolyn, I can't make out the last name, Sadia Woods, and Francis Hun. Welcome.
Thank you. Good afternoon, Chairman and council members. Yes, my name is Gwendolyn Flynn, and I'm a policy director with Community Health Councils, and we're here to support approval of the updated West Adams Community Plan. This plan has been a long time coming. And while it's not a perfect plan, for the most part, it does address the built environment needs of the community, which has implications for the health of the residents there. It also addresses the concerns, and it captures the imagination of community stakeholders. While we support the plan overall, we ask that this body consider reforms to some aspects of the process, to many aspects of the process, by the way, that created it. And I'm going to specifically talk about the hearing notification time. We think it's inadequate. It doesn't give working community residents enough time to really review volume of work. But overall, we want to commend the City Planning Department and Reuben Caldwell and his team for bringing this forward, and ask that you advance it.
Thank you. Sadia Woods, Francis Huyen.
Good afternoon, committee members. I'm Sadia Woods. I'm representing Community Health Councils. And yes, this plan has been a long time coming, but I do want to make note to the fact that the room is almost empty, and I think that is owing to the extremely long time that this plan has been underway and the fatigue of community residents and a little bit of disillusionment of community residents at some of the processes that this plan has undertaken. We would encourage you all to consider reforms to the process that make the adoption process of these plans a little bit tighter, and that provide a way for a community to really participate in a public process in a way that's meaningful. 60 seconds, I said this before, is not enough time for people to make substantive comments on these plans. And my last recommendation to you is that as this plan moves forward, that you would have an additional community hearing somewhere in the community where we can talk about what are the next steps as far as implementation of this plan is concerned to the community residents that participated in this process. Thank you.
Thank you. Francis, Kara Morgan, Damian Goodman.
Hello. Hi, council members. My name is Frances Huyen, and I'm speaking on behalf of Community Health Councils in South LA. I'm here to speak on behalf of reforming the planning processes themselves. I believe that these planning processes should be made more transparent and accessible for the community members that these land use policies are going to impact because they live and work in these communities. One place that greatly needs improvement is the city's planning website, which currently is ridiculously difficult to navigate and locate, especially for those that are unfamiliar with planning jargon. So in other words, the folks that could have been here but aren't here because they couldn't navigate that website. And also the folks that couldn't read those documents because of the jargon. It needs to be made more user-friendly so that these important documents, such as the community plan update, could be easily accessible and not made deliberately inaccessible to these community members. Thank you.
Thank you. Carl Morgan, Damian Goodman.
Thank you. Carl Morgan, Empowerment Congress West Area Neighborhood Council. We would like to thank Reuben Caldwell, Ken Bernstein, and the rest of the planning staff for working tirelessly for almost 10 years, almost a decade in a process to get this plan approved. Also, we'd like to thank the council office staff in CD 8 and 10, Linnell Washington, as well as Jordan Burukim, Andrew Westall, Elizabeth Carlin. We look forward to the implementation and CPIO and eventually enhancing the enforcement of building and safety so that will ensure the improvements to all of our boulevards. And I also echo all the comments before me. Thank you.
Damian Goodman, Linda Ricks, Mary Bryant.
Good afternoon, council members. Damian Goodman of the Crenshaw Subway Coalition. We were clearly concerned about the last time this item came before this body with respect to the many changes, including one regarding the Cumulus project, which we have formally filed suit and you're aware of in court. And we can only commit to not doing similar action to legally challenge this project if the language that's currently in the proposed recommendations, which specifically says that these additional height and density requirements for Cumulus only go into effect for, quote, for so long as the entitlements are in effect, unquote, and guaranteeing that when we successfully win our case in court, that it reverts back to the initial height and density requirements and other requirements within the Jefferson-La Cienega CPAO. I'm going to use my last few seconds to just reiterate how difficult this is as a process. First of all, you're always putting South LA at the end of the agenda. I'm not liking that. But it's at 2:30 in the middle of the day, where it makes it very difficult for members of the community to engage in this process. And when you're proposing such drastic changes, you should be going to the community and providing the similar process that a community plan deserves. Thank you.
Thank you. Linda Ricks, Marie Bryant, Laura Myers.
Good afternoon. I'm Linda Ricks from the Hyde Park Organization for Partnership for Empowerment. I approve this. The one thing that I'm really happy that is in there is a design and review board. Thank you.
Thank you. All right. Next.
Good afternoon. My name is Marie Bryant, and I am a resident and stakeholder in the Angeles Mesa area of CD8. And I want to thank Reuben Caldwell for putting up with us in these many years of our suggestions and kind of beating him up. But I also want to echo Mrs. Rick's statement. We need a design and review board because it is important to and essential to our community and the things that are to be coming to our community. And also, I would like a enforcement and maybe enhancement of the moratorium on standalone fast food restaurants in our area for CD8 and the city of Los Angeles. But all in all, I do support this plan, and I request, and hopefully you'll give us a yes vote. Thank you.
Thank you. Welcome.
Hi, I'm Laura Myers. I'm representing United Neighborhoods Neighborhood Council. I'm the Planning and Zoning Chair, Land Use Chair. And we really do want to thank the Planning Department because in the long wait, we also got them to create the CPIOs for residential overlay, which will then be expanded more widely in South LA. So we have a new CPIO portion for Arlington Heights that will help protect the historic and character of the neighborhood along with everything else. I almost partly echo the concern about how do you engage the community in the reviews of community plans. What we did, United Neighborhoods did, we actually held our own public meetings over and over and over again. So I feel confident when I say hundreds of people in the United Neighborhoods area participated in this process. And that's with the Planning Department attending. So thank you all very much.
Thank you very much. Jordan Burukim from CD10. Welcome.
Good afternoon. Good afternoon, members of the Plum Committee. My name is Jordan Burukim. I'm here from Council President Weston's office. I'm here to ask for your support and approval in moving this matter to full council. Our office would also like to thank the Department of City Planning for their diligence on this matter. The plan has been 9 years in the making and is long overdue. We would also like to thank members of the community if not for them, then the plan wouldn't be what it is today. So we'd like to thank the members of Council Districts 5, 8, and 10. Lastly, as a request from the community, our office would like to request the City Attorney's Office to please prioritize this plan in their form and legality review. And we'd like to thank you for your time. Thank you.
All righty. Any questions or comments on this item? See no questions or comments. We will approve this item.
Excuse me,
Yes, sir.
Mr. Chair. We do have a motion prepared that we would like to read into the record if possible.
Sure.
And you'll have to excuse, I do have to read this verbatim, so it may be a little bit lengthy. Okay. So the motion begins. Staff recommends this committee recommend council take the following actions. Section 1, adopt the accompanying resolution that does the following. Subsection A, certifies and adopts the final environmental impact report, EIR number ENV 2008-478-EIR, State Clearinghouse number 2008-021013, pursuant to CEQA guidelines sections 15090 through 15093, including adopting the CEQA findings, the statement of overriding considerations, and the mitigation and monitoring program. Subsection B, approves proposed text and map amendments to the West Adams Baldwin Hills Lamert Community Plan, Circulation Element, Mobility Plan 2035, and Framework Element contained in Council File number 16-0597, including as modified. Section 2, request the City Attorney to prepare and present ordinances relative to amendments to the existing Crenshaw Corridor Specific Plan Ordinance and the proposed West Adams Community Plan Implementation Overlay CPIO District. Section 3, refer the ordinance approved by the CPC affecting changes of zone and height district as set forth in the exhibits contained in Council File number 16-0597 as modified back to the Plum Committee so that it can be considered with the ordinances relative to amendments to the existing Crenshaw Corridor Specific Plan and the proposed West Adams Community Plan Implementation Overlay CPIO District. And finally, Section 4, instruct the Department of City Planning to update the general plan and appropriate maps pursuant to this action. And we do have copies of the resolution, which does include some minor edits from the City Attorney, and we'd like to place those into the record as well.
Great, thank you. If you could pass those out, please. So we will approve this item as amended and send it to full council. Any objection? Yes, City Attorney?
Councilmember, just to be clear, so the committee's going to adopt staff's suggestions and recommend those actions to council?
Yes. Okay. All right, there's, let me double check that I cleared everything on this. Okay, I think Mr. Mejia, if I'm correct, this is, we're requesting the City Attorney to prepare the Crenshaw Corridor Specific Plan Ordinance and the Community Plan CPIO, approve the resolution to effect amendments to the West Adams Baldwin Hills Leimert Park Community Plan, and approve the zone and height district changes as those items as amended.
Yes, sir.
Okay.
And including the adoption of the environmental clearance that the Planning Department staff read.
Got it. Yeah. Okay. That's the motion. So ordered. Thank you. Any other items on our agenda today?
No, sir, just public comment.
There are no public comment cards. Meeting adjourned.
Mr. Chair, Mr. Chair, Mr. Chair. Ignore me.
Mr. Councilman.
City Clerk.
I just had a question about item 8.
Item 8.
Were you going to continue that item for the ordinance to come back, or did you want it moved to council with the instruction?
No, we could send that to council. That's fine.
Okay.
I mean, we don't need to come back.
No, but the request is for the City Attorney to prepare the ordinance.
Oh, yes.
So do you want to keep it here or ask for that, to give that direction to the council?
Directly to council, please.
Okay.
Directly to council. Thank you for that. Thank you. Good stuff.